Hey everyone, welcome back to Corporate Decoder, the place where we decode the secrets hidden in plain sight within corporate filings. And today we've got a real juicy one from BlackRock Income Trust, Inc. Get ready because we're about to pull back the curtain on their latest filings and see if this income trust is really as steady as it sounds. Before we dive in, if you love these unfiltered looks into company documents, make sure you're subscribed. And hey, we've got a fantastic community over on Discord where we break down these filings even further, so join us there, the link is in the description below. Alright, let's get straight to it. This document is essentially an update, a kind of recertification for BlackRock Income Trust. Inc., think of it like renewing your driver's license, but for a financial company, they are updating their registration statement, which is a big legal document they file with the U. Securities and Exchange Commission, or SEC. For short, it is like their official autobiography for investors. This particular filing is a post-effective amendment, which means they are making changes and amendments to a registration statement that was already approved or considered effective. They are also registering additional securities, basically saying they want to offer more shares of their trust to investors. So, who exactly is BlackRock Income Trust, Inc.? Well, as the name suggests, it is a part of the massive BlackRock family, a company that manages trillions of dollars for people all over the world. This specific trust, the Income Trust, is a closed-end investment fund. Now, what does that mean for you? A closed-end fund issues a set number of shares, and then those shares trade on a stock exchange, kind of like regular stocks. Unlike open-end mutual funds where new shares are created or redeemed based on demand, the number of shares in a closed-end fund stays pretty much the same. This can lead to some interesting price dynamics where the share price might trade at a discount or a premium to the actual value of the investments held by the fund. The income trust part tells us their main goal is likely to generate income for their shareholders, usually through dividends or interest payments from the assets they invest in. The big form here is called Form N-2. This is the standard form that closed-end investment companies use when they need to register themselves and their securities with the SEC. It is incredibly detailed and covers everything from the company's business to its financial condition, risks, and how it plans to operate. It is a crucial document for anyone looking to invest in such a company. Now, while we don't get into the nitty-gritty addresses here, it's important to remember that BlackRock has offices all over the world. This filing is about their operations and compliance with US regulations. This box being checked is super important. It means the shares are being offered on a delayed or continuous basis. This is often referred to as an at-the-market offering. Instead of a big one-time sale, they can sell shares over time as market conditions are favorable. This gives them flexibility, but also means the offering process can be ongoing for a while. This next part, Part C, is where we find the really substantial supporting information. It's like the appendix of the report where they load up all the important stuff that backs up the main claims. This section is all about the supporting documents, the evidence for everything else in the filing. It includes financial statements which are crucial for understanding the company's health, and a long list of exhibits which are basically other legal documents that are part of this registration. Think of exhibits like the legally binding contracts that govern how the fund operates. Here they're referencing their annual and semi-annual reports. These reports are where you'd find the actual numbers detailing the fund's performance, its assets, liabilities, and income. It is the proof of their financial standing. They are incorporated by reference, meaning they are part of this filing, but you'd have to look at those other specific reports to get the exact details. This is a massive list of all the governing documents. We're talking about things like their articles of incorporation, which are like the company's birth certificate establishing its existence and fundamental purpose. Then you have their bylaws, which are the internal rules for how the company is run on a day-to-day basis. There are also agreements with their investment advisors, the people actually managing the money. These agreements are super important because they outline the fees, responsibilities, and how the investment strategies will be implemented. It is really the nitty-gritty of the operational agreements. This particular exhibit points to the Investment Management Agreement. This is the core contract between the fund and its manager, BlackRock Advisors LLC. It details how BlackRock will manage the fund's assets, what fees they'll charge, and their responsibilities. It is like the blueprint for how the money is handled. This exhibit is interesting because it talks about fund of funds investment agreements. This means BlackRock Income Trust is investing in other investment funds. This strategy can diversify their holdings, but also adds another layer of fees and complexity. It is a way to gain exposure to different asset classes or strategies through other professionally managed entities. Now, let's talk about the cost of all this. This table breaks down the expenses involved in issuing these securities. So, the registration fee itself is over $30,000. This is what they pay to the SEC for the privilege of filing these documents and offering their securities. And then you see legal fees and expenses at a hefty $130,000. This is a significant chunk of change, and it just highlights how complex and legally intensive these filings are. Lawyers are definitely kept busy ensuring everything is compliant with the securities laws. The total estimated expenses for issuing these securities are around $195,000. This is just the cost of getting these shares registered and ready to be offered. It does not include the ongoing costs of managing the fund itself. This section is a straightforward none. It means there aren't any other companies that BlackRock Income Trust, Inc. controls or that control it in a way that needs to be disclosed here. It is a pretty simple statement of its independent operational structure within the broader BlackRock umbrella. This gives us a snapshot of who owns the trust. As of the 31st of August 2025, there were 770 shareholders. This number indicates the current ownership base of the trust. It is not a massive retail investor base yet, which isn't too uncommon for closed-end funds, especially during or shortly after an offering. This is a crucial section related to protecting the people running the company. Indemnification means that the company agrees to cover the legal costs and potential financial liabilities of its directors and officers if they are sued for actions taken while performing their duties for the company. This part lays out that directors and officers are generally not personally liable for their actions, as long as they acted in good faith and without willful misfeasance, gross negligence, or reckless disregard for their duties. It is a standard protection clause that encourages qualified individuals to serve in these roles without excessive fear of personal financial ruin for ordinary business decisions gone wrong. This section goes into detail about when indemnification is required. It essentially says the fund will cover legal defense costs and pay liabilities for its directors and officers to the fullest extent allowed by law, as long as they did not engage in what is called disabling conduct, such as willful misfeasance or gross negligence. It also outlines the process for determining entitlement to indemnification, often involving independent directors or legal counsel. This section provides clarity on what good faith means in this context. It allows directors and officers to rely on information provided by company officers, legal counsel, accountants, or other experts. This is important because it means they are not expected to be experts in every single area and can reasonably delegate or rely on the advice of professionals. This is a key point. Even if someone stops being a director or officer, the indemnification protection they earned while in office continues to apply for actions taken during their tenure. This ensures long-term protection for those who have served the company. This states that the directors can maintain insurance policies like errors and omissions or directors and officers insurance to further protect the fund and its leadership. This is standard practice for companies to manage risk. This is a very important legal disclaimer regarding liabilities that might arise from violations of the Securities Act of 1933, which is the law governing public offerings of securities. The CAC has stated that indemnifying directors and officers for these types of liabilities is against public policy. So, while other indemnification is provided, the SEC essentially says that if a director or officer is found liable under the Securities Act, the company cannot legally pay for that liability, except in cases where they successfully defend themselves. They will challenge any claim for indemnification on this specific matter. This section tells us who is actually managing the money and what else they are involved in. So, we have BlackRock Advisors LLC as the main investment advisor, and BlackRock International Limited or BIL as a sub-advisor. This means there are usually two layers of management involved, each with its own responsibilities and fees. Instead of listing out all the officers and directors of the advisors and their other jobs here, they are simply referencing their Form ADV filings. A Form ADA is a filing that investment advisors must make with the SEC, detailing their business, services, fees, and any disciplinary events. This is a common way to streamline filings, pointing to other official documents that contain the required information. This is just a statement that they are omitting this information as allowed by the rules. It basically means the specific locations of the fund's accounts and records are not being disclosed in this particular filing, likely for privacy or security reasons. This is marked as not applicable, meaning there are no management services to report in this specific context beyond what is already covered by the investment advisor agreements. This section is all about the promises the company makes in connection with this filing. This undertaking reiterates the delayed or continuous offering we saw earlier. It means they are committing to certain actions related to that offering. This is a critical promise. They are agreeing to file updates to the registration statement whenever necessary while the shares are still being offered. This means they will make sure their prospectus, which is the main document investors read, is always up to date and compliant with investor protection rules. If anything major happens that fundamentally changes the information initially provided, they promise to update the prospectus through a filing. This ensures investors always have the most current and relevant information. Essentially, if they change how they plan to sell the shares or any important details about that plan, they will update the filing. This is a powerful legal undertaking. It means that for any future legal issues under the Securities Act, each amendment they file will be treated as if it were a brand new registration statement. This holds them accountable for the information in every update. If they don't sell all the shares over time, they promise to formally remove the unsold ones from the registration. This cleans up their filings and ensures they are only registered for what they intend to sell. This is a very protective undertaking for investors. It means that no matter how the shares are sold, if the communication comes from BlackRock Income Trust, Inc. itself, or is prepared on its behalf, and contains material information about the trust or its securities, BlackRock itself will be considered responsible for that communication to the buyer. This broadens liability to ensure investors are protected by all communications related to the offering. Finally, we have the signatures. This is where the key people at the company officially sign off on the document, declaring that the information is true and accurate to the best of their knowledge. Here we see John M. Pawlowski, the President and Chief Executive Officer, signing off. This is his official confirmation that the information in this registration statement is accurate. And then we have the signatures of the directors, along with the principal financial and accounting officer, confirming their roles and agreeing to the contents of the filing. It is a collective accountability for the information presented. This is just the table of contents for all the additional legal documents that are part of this filing. It's a roadmap to all the exhibits we discussed earlier. This exhibit is an opinion from the company's lawyers stating that the shares being offered are legally valid and properly registered. It's a crucial piece of legal validation. So what is my take on this filing? Well, it's highly technical and primarily administrative, focused on updating their registration and offering additional shares. We don't have direct financial tables here to analyze performance in this particular filing, but the fact that they are continuing to offer shares and updating their registration suggests they are confident in their ability to attract investors and manage their assets. The indemnification clauses are standard but important for understanding corporate governance. The undertaking to file amendments and provide updated prospectuses shows a commitment to transparency with investors, which is always a good sign. The fund of funds strategy, while potentially diversifying, can also mean more fees, which is something investors should always be mindful of. Overall, this filing is less about immediate financial results and more about the ongoing operational and legal framework of the BlackRock Income Trust, Inc. It's a company that is actively managing its structure to continue operating and offering its investment products. Alright, that is our deep dive into the BlackRock Income Trust, Inc. filing. What do you think about these kinds of administrative updates and what they signal for investment trusts? Let me know your thoughts in the comments below. If you found this breakdown valuable, please hit that like button and subscribe for more in-depth corporate analyses. And don't forget to join our Discord community. The link is in the description to continue the conversation. Thanks for watching, and we'll see you in the next one.